Winston, over here.
All right, it's a Viva on the street, and it's an update that has nothing to do with the Kyle Rittenhouse case. This is the other pending murder lawsuit that has been making the headlines, but not quite as much as the Kyle Rittenhouse case, the Ahmaud Arbery murder case. Now, this is a malice murder, felony murder case coming out of Georgia. And for anybody who may not have heard about this case, I don't know where you live that you wouldn't have heard about this case because it's been everywhere, but not as much as Rittenhouse. This is the case that originally started off as the LeBron James, you can't even jog in America while being black, because the story as it initially broke was a black man jogging through a Georgia neighborhood, gunned down by two individuals who got in their pickup trucks with guns because they suspected a black jogger of being a burglar. Now, that narrative sort of fell apart, but not in a meaningful sense, because even according to the prosecution, they are prepared to concede that Ahmaud Arbery was not jogging through a neighborhood when he was pursued by the individuals, the McMichaels, father and son, and another individual who recorded the whole thing, one of the neighbors. Prosecution concedes that that narrative was probably wrong, but that does not justify basically hunting down and killing in the streets an individual who, even according to the defense and the prosecution, was suspected of burglary. The defense of the defendants is that they were effecting a citizen's arrest, as they were within their rights to do under Georgia law. Now, the nuance is, under Georgia law, in order to effect a citizen's arrest validly without committing a felony yourself, you have to have probable cause that a felony has been committed, which is where the distinction between burglary and trespass becomes somewhat important, in that burglary could be felonious, but trespass is generally a misdemeanor. So even if the McMichaels had suspected Ahmaud Arbery was trespassing on property that was not his own, definition of trespass, it would not have been felonious to justify a citizen's arrest. If it were burglary, it could, in theory, justify a citizen's arrest, given the felonious nature of burglary. This is where it gets a little more nuanced. If you suspect someone of a felony, you have to have probable cause that the felony has occurred contemporaneously with the attempt at citizen's arrest. So if you suspect someone had committed a felony a week ago, 2 weeks ago, a month ago, a year ago, well, that does not necessarily give you the right to perform a citizen's arrest in a time frame that is sufficiently separated from the alleged or suspected felonious act itself. And according to the defense, which is the big admission that basically might sink this case, the day of the attempt at the citizen's arrest, they had no firsthand knowledge or probable cause that a felony had been committed the day they attempted to perform the citizen's arrest. They suspected that Ahmaud Arbery was the individual who allegedly was terrorizing the neighborhood. In the weeks prior to, there was an event that occurred a week and a half before the attempt at the gone sour citizen's arrest that led to Ahmaud Arbery's death. There were allegations that there were robberies, and they suspected Ahmaud Arbery was the individual who had committed those burglaries a week and a half prior to the attempt at citizen's arrest. And even if that's the case, under Georgia law, that would not allow the McMichaels, father and son, to perform a citizen's arrest on the day of, when they had no probable cause to believe that a felony had been committed within the time frame required to perform a citizen's arrest. The defense admitted this, and that really seems to put the nails in the coffin of the McMichaels' defense. They're being charged with malice murder, which might be a bit of an overstretch, but under Georgia law, they are also being charged with felony murder, which is when you're committing a felony, if a death results, you can be charged with felony murder with basically the same sanctions as murder itself. And the idea here is that if the McMichaels did not have probable cause to believe that Ahmaud Arbery had committed a felonious burglary the day of or within a reasonable, relevant time frame from within which they were attempting to perform the citizen's arrest, they're committing a felony of what is known as false imprisonment, basically telling an individual at gunpoint, which is itself a felony, you have to stay with us, even though there's no lawful basis for them to say that. So the idea now is that if the McMichaels had no probable cause to suspect a felony had been committed the day they were performing what they thought was a citizen's arrest. They are the ones performing the felony right now. And if Ahmaud Arbery dies in their commission of a felony false imprisonment, they are now guilty of felony murder.
What is the defense? We got self-defense. What is that? Well, they're going to try and convince you that Ahmaud Arbery was the attacker, that he was somehow threatening to them. 3-on-1, 2 pickup trucks, 2 guns. Mr. Arbery, nothing in his pockets. Not a cell phone, not a gun, not even an ID. They want you to believe that he is the danger to them. And Mr. Rubin said it in the opening statement. He was scary. So here's the thing. They're going to try to claim that they were justified in their actions. Okay? Because here's the thing, ladies and gentlemen. You cannot claim self-defense under certain circumstances. You can't. You don't get to say I was acting in self-defense, and there's 3 of them, and it's the law. This isn't just something made up. There's 3 of them in the law, okay? If you are the initial unjustified aggressor, you don't get to claim self-defense. If you're committing a felony against somebody, you don't get to claim self-defense. And the 3rd one is if you provoke somebody so that they defend themselves against you. And then you go, oh, look, he attacked me first. But you really were the one who was provoking the attack on yourself. You don't get to claim self-defense. And that's the law.
The prosecution, in their closing arguments, did a great job. It reeked a little bit of a TED talk, but that's fine. That's performance. That's, gray zone sort of critique. The prosecution did a great job basically getting in advance of what the defense was going to allege as their defense, saying these guys thought they were pulling over someone for burglarizing when they had no probable cause to pull over Ahmaud Arbery in an attempt to perform a citizen's arrest the day of. They called it the driveway decision. The McMichaels basically in their house saying on their driveway, we think this guy just committed a felony of burglary, so we're going to go perform a citizen's arrest. They had no reason to suspect that a felony had been committed then. All that they had was a neighbor saying, that's the guy that we think did something a little while back, which is not direct knowledge of an actual felony. That is basically hearsay suspicion of a felony. So they had no probable cause to attempt to carry out the citizen's arrest. And in so doing what they did, they basically performed felonious false imprisonment. The defense did the best they could with the facts they had in terms of trying to create the environment, set up the scenario where you have a neighborhood that is living under the terror of nighttime burglaries, and they're painting the image that it was Ahmaud Arbery who was the one guilty of these nighttime burglaries, even though Ahmaud Arbery had not been arrested, tried, convicted, or anything of these previous burglaries. They're trying to say they were all living in a neighborhood of terror. So much so, and this is what the defense alleged, that a neighbor across the street wouldn't let her kids go out at night anymore because of the burglaries, yada, yada, yada. The only problem being when they attempted to make the citizen's arrest on Ahmaud Arbery, it was not at night. He was not carrying anything. And so even by their own theory of the defense, 2 elements, the nighttime burglarizing, were not present when they attempted to make their alleged citizen's arrest of Ahmaud Arbery. So they did their best. But this was a case where the prosecution's facts are so strong that even Binger and Krause himself could have succeeded in making a compelling case for the prosecution. But the prosecution basically just argued that even if they thought they had all the reasons in the world, even if they thought that this was an individual who had been burglarizing the neighborhood a week and a half prior, that did not give them the right the morning of to try to effect a citizen's arrest. And in attempting to perform a citizen's arrest that was bungled and led to Ahmaud Arbery's death, they were guilty of the felony of false imprisonment leading to death, therefore felony murder. The malice murder might be the harder charge to actually succeed on, but ultimately it won't change much because felony murder is going to carry basically the same sentence as malice murder itself, maybe a little less. The one individual who has a bit of a chance in all of this, I forget his name right now, the individual recording the events, who was not related to the McMichaels, and is going to basically allege, and did in closing, because they all have separate counsel, that he had no idea the McMichaels were armed at a certain point. When he became aware of the fact that they were armed, too late. He had no intention of wrongfully detaining, false imprisonment of Ahmaud Arbery. He was not participating in this felonious act that led to the death of Ahmaud Arbery. Therefore, he's not guilty of felony murder. It's going to be tough because some of the admissions he made was that he participated in the car chase of Ahmaud Arbery. In his testimony, he said, "I wish I had hit Ahmaud Arbery with my car," in the sense that had he hit Ahmaud Arbery, maybe it would not have escalated to Ahmaud Arbery getting shot by Travis McMichaels.
But it's clear that Mr. Bryan did not wish to strike Mr. Arbery, that he never had any intention of hurting Mr. Arbery. He never said anything to the contrary. The evidence will show that he had no knowledge, no reason to believe that anyone else out there meant to hurt or shoot Mr. Arbery. If they had a secret intention or desire to do that, it could not be known to him.
That's true.
Now, the truth of what Mr. Bryan is trying to convey hasn't really changed.
Okay, it's a fair point. He says, "I wish I had hit him." It obviously was not to hurt him or kill him because that had already occurred. So he's saying, "I wish I had. It would have avoided the tragedy." And I think I can believe that interpretation.
Yeah, I agree with you.
He's got some problems, but he's got the best chance of exoneration or not getting pulled down in the felony murder. Travis McMichael, the one who pulled the trigger, I suspect and I'm predicting is done for. His father, I think he's pretty much done for as well as far as the felony murder charges go, even though, you know, he's on the phone with the cops and telling his son no. But at that point, they're already involved in this pursuit of false imprisonment, which is itself a felony when you don't have the probable cause to effect a citizen's arrest for a burglary that you neither witnessed nor is even alleged to have occurred the day of the citizen's arrest. So it is not as controversial, it's not as divisive of a trial as Rittenhouse, because I think the facts in this case are just uglier. They're so ugly that the prosecution has an easy time making a good case of it. The defense is doing their best at making a decent defense out of it, but the outcome, I think, is going to be felony murder for the McMichaels, and maybe, if he's lucky, not guilty for the individual who was recording it, who, you know, allegedly collaborated, participated, cooperated with the cops, turned over all his video evidence, which, you know, in theory is not what you would do if you were participating in a felony murder. Flip side is that this individual may not have even appreciated he had participated in a felony murder, so he didn't know that he was actually handing over incriminating video footage to the cops when he handed it over. Lots of lessons to be learned in all of this. Some people don't like the lesson I take from all of this, which is property, suspected burglary, robbery is not worth escalating the way this escalated. A lot of people want to draw some similarities between this and the Rittenhouse case, with some major distinctions that cannot be ignored. In Rittenhouse, it was Rittenhouse, the armed man, who was being pursued by felonious individuals, people who wanted to cause him harm, whereas in the McMichaels case, it was the armed individuals who were pursuing the unarmed man, put him in a position where this guy effectively thought, I'm cornered by armed men. What do? You might make the wrong decision, but it might be an understandably wrong decision given the circumstances. So fundamental differences. They are not analogous cases. That is the McMichaels case. We're going to see what happens with the verdict. Closing arguments are closed. If you want thorough analysis, go check out Nate Brody, Joe Neerman, good logic. But we'll see what the judgment comes down as. I don't think it looks good for the McMichaels. I didn't think it looked good from the beginning. And we'll see if that turns out to be true. So with that said, if you like my content, you know what to do. Links are in the pinned comment. And what do you say? I'm cold. Peace out. Booyah!
Things you own end up owning you.